Okay, right before we get started, I just want to plug a little link in the chat so you guys can take a look at that before we really get started talking. And this is for the ERA Centennial Convention, which is why we are all here today. So this series of workshops that are going to be going on in this June, the second one is this week, are all to help prepare our audience, whether you're new to the ERA movement or you've been here for a while, help give everyone that background knowledge as to why the ERA is important and its different contexts within the law, so everyone can be that legal expert and come and attend the ERA Centennial Conventions with your amazing opinions and amazing perspectives and share that with all of us. So on the chat, I'm going to drop a link to register for the ERA Centennial Convention. And we're going to be dropping a lot of links, but I just want to drop this one because this is obviously a very important one. I want to give you all some time to look that over, especially now. But that is the link to register an RSVP for the actual Centennial Convention happening later this summer, July 21st and 22nd. It's organized by some amazing activists, amazing people all on this call today. Kate Kelly is an amazing person I'm grateful to work with. Many people on the planning committee, part of the ERA project at Columbia University, all working really hard to put this event together and put together these beautiful workshops as well, these virtual workshops, the second of which we are starting today. So please make sure to take a look at that link, and we're going to go ahead and get started. Okay, so welcome everyone to the second workshop in our Reimagining Gender Justice. This is a series of 5 workshops coordinated by the Equal Rights Amendment, or ERA project for short, by the Columbia Law School and Generation Ratify. So today's workshop is on gender justice in the law, historical and existing frameworks. So today we're going to introduce some debates surrounding the Equal Rights Amendment within the broader context of gender justice in the law. And this session, as I said before, is going to help provide everyone with that vocabulary and terminology you need to talk about issues such as gender justice within constitutional law. And also help give everyone a brief historical introduction to the Equal Rights Amendment. So this workshop is going to be held once a week in June, and it's all leading up to our convention in Seneca Falls, New York, this July 21st and 22nd. And I'm going to introduce our wonderful panelists for today, starting with Ria Tabakomar, who is the director of the ACLU Women's Rights Project. We also have Michelle Kallen here with us today, who is a partner at Jenner & Block and former Solicitor General of Virginia. And Katherine Franke, who is a James L. Dorr Professor of Law, Director of the Center for Gender and Sexuality Law, and Faculty Director for the ERA Project at Columbia University. So I'm going to pass it on to Ria to further introduce themselves, and if we can have each panelist today briefly introduce themselves and begin the discussion for today.
Not sure if you want me or Michelle. I see Michelle is pinned, so I'm happy to have her go first, and I can jump up as my picture joins. Sorry to put you on the spot, Michelle.
No worries at all. Hi, everyone. It's nice to see you all over Zoom. So I'm Michelle Kallen. I am in the Supreme Court and appellate practice of Jenner & Block, which is a national law firm. But before that, I served as Deputy Solicitor General and then Solicitor General of Virginia. So I was in Virginia state government when Virginia became the 38th state to ratify the ERA. And then helped lead the charge when Virginia, Illinois, and Nevada sued to vindicate our state's ratifications when the Archivist of the United States did not certify and publish the ERA. So I spent a lot of time in my professional capacity working on ERA issues, but also it's probably one of the issues I'm most passionate about and spent a lot of free time thinking about this issue and caring about this issue. So I'm very excited to be here.
Welcome everyone. I'm Ria Tabagomar. I use she, her pronouns. Loving the energy in this Zoom room and in the chat. It is so energizing to see so many young people fired up about the ERA. And it's really bringing me a spring in my step as we think about all of the work that's ahead of us. As Pooja mentioned, I'm the director of the ACLU Women's Rights Project. I previously have been an attorney with our LGBT and HIV project, and also with the NAACP Legal Defense Fund. So I have a real interest in intersectional forms of discrimination. I also want to say the ACLU has several special connections to the ERA and to constitutional sex equality. The ERA was authored by Alice Paul and Crystal Eastman. Crystal Eastman was one of the original founders of the organization that became the ACLU in 1920. So we're very proud to call her one of our founding mothers. And of course, the foundation for today's modern constitutional sex discrimination law was laid and then built by the late Ruth Bader Ginsburg, who founded the ACLU Women's Rights Project in 1972. And won several landmark cases between 1972 and 1980 while she served, that created what we now know as heightened judicial review for sex-based classifications under the Constitution, work that she continued on the bench when she became a Supreme Court Justice. And I'll pass it to Katherine.
Thanks, Ria and Michelle and Pooja. It's really my honor to be with you all today. As Pooja said, I'm at Columbia Law School, and I founded the ERA project at Columbia several years ago, largely in order to bring academic, rigorous analysis to the ERA to supplement all the great work that's being done by other advocacy groups, both on the national and on the local level. And just to lift up Michelle for a second, in addition to Ria's amazing work at the ACLU on the national level, Michelle's work in Virginia to get Virginia across the finish line and the ERA across the finish line was just so incredibly important. So too in Illinois and Nevada, who were the other last states to join the club. And so I really want to applaud that local work that's being done in states across the country to think about what it means to live in a society with a 21st century version of sex equality protections, not the 19th century version of protections that we have in the Constitution now. And one of the main things that we do with the ERA project is kind of break down the complex constitutional stuff that surrounds the ERA, like these new decisions that are coming out of the federal courts, or what does heightened scrutiny mean under the Equal Protection Clause? Why do we still need the ERA? What are the legal problems that stand in the way of everybody recognizing that it is already the 28th Amendment? And if you go to our website, you can see what we call a bunch of splainers, but not mansplainers, but woman-splainers of what all this stuff means and basically how to explain it to your mom. Please see us as a resource for breaking this kind of complicated constitutional law down. And if there's things you'd like us to be working on, things that you'd like to get a better grip on or have a better handle of how to explain to other people, let us know, because we can certainly do that in partnership with you. And I'm just going to drop in the chat the link to our site so you can get all that stuff there.
I'm just going to open it up to the other panelists. If you would like to touch on any topics regarding the 14th Amendment and why we need those strong legal protections that we would have in the ERA, the need as well for inclusive language within the Equal Rights Amendment, and why we need that kind of constitutional review. If you would like to have a conversation on this, and that would be amazing. I'm going to pass it off to Michelle to start us off.
Sure. So yeah, one of the big conversations around the ERA is, why do we need an ERA? The 14th Amendment has already been interpreted to protect against sex-based discrimination, so the ERA will just be a symbol, and who cares about symbols? And for a while, the conversation was about, well, symbols matter, and it's important that our Constitution expressly protect against sex-based discrimination, and that's still all extremely important. I have a 9-year-old and a 3.5-year-old, and I would love for them to be able to pick up a copy of the Constitution and see, protect sex-based discrimination expressly there where they can read it. And so that's still very important. But I think in light of what we've seen on the Supreme Court, and in light of how we see case law evolving, I don't think that we can so comfortably just rest on the interpretation of the 14th Amendment as it's been. So first, it's important to note that sex-based discrimination under the 14th Amendment, just the existing law that, Justice Ginsburg and a lot of others played a really big role in facilitating, that sets forth a lower level of protection for sex-based discrimination than other forms of discrimination, like race-based discrimination. So it's protected at a level of protection called intermediate scrutiny. And what's intermediate about it is it scrutinizes less than protections against like race-based discrimination, but it scrutinizes a little bit more than protections against other forms of discrimination that are kind of based off less protected characteristics. So even the baseline 14th Amendment protection is not kind of the most heightened level of scrutiny. But even there, that's not fully set, not something that we can completely rest on today, because as many people might know, the Supreme Court in the last couple terms has been very fond of overturning precedent, as we know from the Dobbs case and the overturning of Roe v. Wade. But even a step further, a lot of that is done based off originalist interpretation of the Constitution. And that's the idea that we should interpret the Constitution and we should interpret statutes based off how the drafters of those provisions kind of understood what they were doing at the time. Well, it's not disputed that at the time of the 14th Amendment, it was never intended to protect against sex-based discrimination. So if the court's not going to respect its prior precedent and be open to overturning precedent, and if the court is looking at the 14th Amendment based off how it was understood at the time that it was enacted, then even our existing 14th Amendment protections against sex-based discrimination are at risk today, which shows how important it is to recognize the Equal Rights Amendment as part of the Constitution.
I would love to build on Michelle's excellent explainer of 14th Amendment sex discrimination law, and just point out some additional holes in the current equal protection jurisprudence that we are still litigating today in the Women's Rights Project. So much as Michelle said, she often gets the question, why do we need the ERA? We in the Women's Rights Project often get the question, like, oh, you must be busy working on abortion. I say, no, that's our colleagues in the Reproductive Freedom Project. Oh, well, what do you do then? As if the work is all complete. All of you are here today, of course, because we know that work is far from complete and women experience sex discrimination in all kinds of places outside of our reproductive choices, including when we choose to or end up carrying pregnancies to term. But one of the holes we've been trying to fill is really to ensure that courts actually do apply heightened scrutiny to every sex-based classification and not just some sex-based classifications. And we've seen real pushback there, even though many people considered it sort of Justice Ginsburg work to have done either at the time that she left the ACLU, or some people thought that she sort of completed that work when she was on the bench, when she wrote an opinion in the Virginia Military Institute case, which ended VMI's policy of barring women from enrolling, and many people saw as sort of the capstone of her career. Just even despite the decision in VMI, we still see courts reject the idea that heightened scrutiny automatically applies to sex-based distinctions the way that other forms of scrutiny could apply to other distinctions. So for example, we do a lot of work around student dress codes. We're litigating right now a case about whether girls can be forced to wear skirts as a condition of attending school. And in the dress code context, we've seen quite a few courts suggest that perhaps heightened scrutiny does not apply because there's something different about dress code. Perhaps it seems too trivial. It's not important enough. It's not the kind of real sex-based distinction that the Constitution is concerned about. Or at the other extreme, we have also litigated cases involving discrimination against service women. And there we see the court saying, well, the military is just so important that we can't possibly apply heightened scrutiny in the way that we ordinarily do because we have to give greater deference to the government's desire to discriminate in this context. So to sum it up, sometimes sex discrimination is either too important, right, or it's not important enough to be worthy of judicial review. But either way, it's clear that we don't treat sex discrimination, courts don't treat sex discrimination the same way that they treat other forms of discrimination, and they feel much more comfortable carving out whole spheres of discrimination that somehow don't count or aren't worthy of judicial scrutiny.
Thank
If I
you
can
both.
add just one last, can I add one last thing, Pooja?
Yeah,
or
of
do you wanna
course.
jump
I was
in?
just about to open it up.
Okay. So one thing I'd like all of us, particularly the group that's shown up for tonight, to think about is how to dream a little bit larger about what the ERA can do. You know, the 14th Amendment was passed, was ratified in the 19th century. And it had a particular project, which is about sort of healing the country and bringing African-American people into the American citizenry and personhood, really. And that made sense at the time. But how the Equal Protection Clause has evolved, particularly with the Supreme Court's conservative trend over many years, is to freeze the idea of equality that we have in the Constitution, even at its best in race-based cases, in a form that has done nothing really to dismantle race-based subordination and discrimination. And so very often you hear people say, oh, what the ERA will do is it will get sex discrimination the same treatment that race discrimination gets under the Constitution. Yay, that would be wonderful. Well, no, it wouldn't. Race equality protections under the Constitution have, for the most part, benefited white men. And we have also seen increasingly that the even less protective protections that we have for sex-based discrimination have really come to the rescue of men more than women in so many cases. And an excellent example is a 2021 COVID case where there was a challenge to the federal COVID stimulus package that identified restaurants as one industry that had been particularly hurt by COVID, obviously, because restaurants all closed for some period of time. And the Biden administration in the bill fast-tracked checks to or payments to women-owned and people of color-owned restaurants because they were the ones that the data showed had been hurt the most by the closures related to COVID. It's not that white men or other people were not going to get checks. It was just that the first 2 weeks, the checks were first going to go to women-owned and people of color-owned restaurants. And a white guy in Tennessee, Anthony Bottolo, challenged that policy of fast-tracking those checks because it discriminated against him on the basis of his sex and his race. And he won, and he shut down that entire program for everybody. So, so what the Constitution does is come to the rescue of white men in cases where they're challenging really sincere and well-documented efforts to lift up or dismantle forms of structural racism and sexism. And what we need in the ERA is a completely different way to think about equality, not tied necessarily to the 14th Amendment, which has been miserable in addressing sex and race-based equality, but a new substantive form of equality. And that's what I would urge us all to think a little bit more robustly about, is what would we do with the 21st century version of equality that doesn't just build a little bit better version of what we have in the 14th Amendment into that language, but actually thought differently about all of it.
Thank you so much to all our panelists for sharing that. I think that was an amazing introduction to our questions for today. And I'm going to drop the first question in the chat so everyone can follow along. But I just want to ask our panelists, I'm going to start with Katherine and ask, why is it symbolically important for the Constitution to include sex and or gender?
Well, I think all of our answers to your last question were that it does a lot more than, and it should do a lot more than symbolism, but just on the symbolic level or on the representational level, given that women, people of color, people who didn't have money, whole Native Americans, all sorts of people were not full citizens, let alone full people. at the founding of this country, it's important that we have a document that constitutes the United States that recognizes everyone as citizens and citizens under the same terms. And then how that gets played out through litigation, through policymaking in Congress and in the states and in local governments, obviously is critically important, what the Constitution requires. But just seeing yourself in the Constitution as a full member of our political community is extremely important. And it's important to note that also that the 14th Amendment doesn't mention race either, right? And I think if I were drafting the ERA today, I would mention more than sex. But this is the language we have right now. But New York State is going to be amending our Constitution to add explicit sex, race, sexual orientation, gender identity, disability, pregnancy outcome, et cetera, protections in the next year, which is really great.
I'm going to open it up to the other. Oh, go ahead. Perfect.
Yeah, I'm happy just to jump in. I mean, I think, you know, symbols are important and our Constitution is important, and our Constitution is an embodiment of who we are as a country and what our values are. And if something isn't important enough to be in our Constitution, that sends a message both to people living in the United States about who we are and what our values are. And it sends a message, you know, to folks outside the country about who we are and what our values are. And so, you know, and when the United States works on helping other countries draft their constitutions, we insist on them having an equal rights amendment. So what does that say about us as a country if we're expecting this of other countries and we're saying this is necessary for you to do, but we don't do that ourselves? There's something very important about us living the values that we, you know, at least purport to expect of others. And so there's a lot more to the ERA than it being a symbol, but also as a symbol, it's extremely important.
I'll just briefly add, obviously, it's no accident that women, sex, and gender are not mentioned in the Constitution. And of course, Black Americans and Native people are mentioned in incredibly derogatory and dehumanizing ways. But I think the fact that patriarchy and the subjugation of women would sort of warranted no mention at all shows that it was sort of taken for granted. It didn't even need to be said. And in many ways reflects the fact that even today, I think we still see patriarchy operating as all too often, you know, so omnipresent as to be invisible and as to be seen as inevitable in ways that other forms of oppression we recognize sort of require constant attention and constant fertilization to be maintained. The same is true of patriarchy, but we have different narratives around it. And I think the failure to mention our subjugation at all is itself quite telling and needs to be corrected.
Yeah, I think that's a great point, and kind of building off that, it sets this default, right? That just the default is what our founders looked like, what our founders thought, and then you have to kind of proactively fight against that. I'll put in a quick plug for Kate Kelly's fantastic book, where she highlights that at the time of the founding, this idea that the default was leadership is expressly white and male, that wasn't something that was, you know, the accepted situation throughout the world. In fact, women were the people who negotiated land deals.
Oh no, I think Michelle's
we lost
connection
her.
might have cut out, but we can definitely follow up on that point as soon as we get her back. There's a follow-up question in the chat. Oh, Michelle's back. Okay, I'm gonna pass it back to you.
I don't know when I lost.
Ooh.
I think the audio still might not be working. We still can't, at least I can't hear you. Do you want to try calling in? Okay, amazing. Thank you.
I think you were going to direct us to the follow-up question in the chat about how the ERA is different. I think this builds directly on Katherine's point about building a more substantive vision of equality, because if we just import the same analysis that we've used from the 14th Amendment to the ERA, we're going to have we're going to suffer the same. Right? We need a sort of concept that does not just sort of dictate a test, but rather focuses on the end blind. And so that's, I think, what the ERA offers, is sort of a chance to start over, knowing what we know now about how equal protection case law has developed, which, in fairness, the 14th Amendment, though it doesn't mention race, of course, did have an express intent to dismantle, the legacy of chattel slavery in America. And it has been twisted. It has been twisted to become sort of, race blind as opposed to anti-subordination. I don't think it's consistent. Folks building out those early equal protection race-based cases, may not have seen where the story was headed, but we here on this Zoom think have a chance.
Our current constitution against people of color or women or both. And so much of the way in which patriarchy and racism perpetuate themselves are through structures, not through the intent of a bad racist or sexist actor. We have a great model in the environmental justice area where, say, in order to build a new road or a new highway or build a new housing development, you have to do an environmental impact study first. How is this going to impact the environment? And if it has a negative impact, then you have to ameliorate in some ways those negative impacts. What if we required that? Let's see, perpetuate inequality or start to dismantle it? And if the study in advance shows that it will perpetuate sex-based inequality, then that's a form of discrimination that the law will prohibit. So there are all sorts of different and more affirmative ways to think about what discrimination, or even better, what equality looks like, that are the standards we see in international law and in many other countries around the world that we call substantive equality. What are the results of these policies? Not just the inputs of racist or sexist thinking, but how do they change the world or perpetuate forms of inequality? And that's something that a new 28th Amendment, a 21st century version of equality could do, that's so different from what the 14th Amendment does, which is basically locked in.
That all makes a ton of sense, and I think it gets at this idea of that at least in my space, in the legal space, people just approach this idea that when you look at a law, when you look at the Constitution, you're trying to envision what people at the time thought, and then you're just kind of having that be the baseline. And I think our society functions around that too, that unless you're kind of affirmatively thinking about where there's some injustice, by just continuing to accept things as they are, that's an implicit acceptance of that overarching system. And so I think that being proactive and looking at the 28th Amendment and the fact that this will be, just one of two constitutional amendments that we've had in the last 50 years, it's a little bit of a kick in the behind to start really thinking a little more proactively about what our society should be and how we can affirmatively improve, rather than just kind of keep things as the status quo, because the status quo really entrenched a conscious decision that was made at the time of the founding to exclude women, to treat people on the basis of all kinds of classifications as inferior to what the default was at the time. And that was a conscious decision. And by not waking ourselves up to be aware of that, we're continuing on with that system.
Listening to Michelle also reminds me that, the text of the ERA had sort of a 2-year look back period built in on this theory that the ratification of the ERA would be the occasion to proactively not wait for people to then sue under the ERA and laws and have judges analyze them, but actually just for legislators to go ahead and look and say, what are our current laws in the books and how do they perpetuate sex discrimination, and what updates do we need to make in light of the ERA, right? So it's a real call to action, not just in the back end for judicial review, but on the front end. And I think Virginia becoming the 38th state in some ways is that call to action, whether or not the archivist agrees the amendment has been validly adopted, right? We can still take those actions now, and we can still be calling for that in many places, as I think is happening.
Yeah, we actually are seeing this play out in the abortion context too. I mean, there were all these states that had these laws banning abortion that were never taken off the books because they were blatantly unconstitutional. Virginia's constitution still prohibits gay marriage. And every year there's an effort to take it out of the Constitution, and it's not successful. And people are like, well, it doesn't do anything because we have other, Supreme Court cases that protect this right. But we can't be complacent because, as we've seen in the context after Dobbs, these laws just being on the books in and of themselves, one, they cause symbolic damage, but two, as the law changes, they can take effect suddenly. And so the call to action in the ERA is extremely important.
Thank you all so much for providing your insight on that. Going off of that, I know we talked a lot about what we don't have in the Constitution, but I'm going to paste a question in the chat that basically asks, if you can first consider your experience growing up without a federal equal rights amendment, have you felt that you've been vulnerable to being treated differently? And what would it be like to have that legal framework explicitly discuss sex equality in our Constitution? And I'm going to direct that to Ria.
So I have to say, I don't know that growing up, I knew much about the ERA at all. Part of what's so exciting to me is to see people who are in high school and college on this call really so firmly being, embracing the ERA and thinking about what it mean. I think I fall a bit into a sandwich generation that was sort of, behind the kind of first wave of ratifications, and then, ahead. I think I've gotten my ahead, behind, you know what I mean, in between, right? These real time periods of momentum around the ERA, and the ERA sort of seemed like an anachronism, not something that was active. What I did know, or what I do think about sometimes, is sort of what it would feel like, to wake up in the morning in a world without patriarchy, what it would feel like to sort of open my eyes and put my feet on the floor, and how would that impact every single choice that I make, beginning with, like, what clothes would I wear? How would I dress my body differently? Like, what would I eat? How would I walk down the street, right? And it's every single decision we make. And I love this exercise because it's almost impossible for me to complete it. I can't do it, actually. I don't know what the answer to those questions are, which I think is really sort of both tragic, but also inspiring. And that's because in every moment of our lives, we're treated differently based on sex. And for me, race as well, which are impossible to distinguish. And I can't imagine, what a world without those forms of oppression would look like. But I know that I'm fighting for it, right? I'm dreaming of that freedom for myself. I'm dreaming of that freedom for everyone on this call.
Yeah, I think one thing to keep in mind is that even if the archivist tomorrow recognizes the ERA as part of the Constitution, and we don't have a million lawsuits popping up to dispute that, is that going to change things on the ground so profoundly? Maybe not, but it is something important in terms of facilitating the conversation to change some of these systems that have been so entrenched into how we function as a society. I can say, as someone who practices in a space that is very non-diverse on any metric you can imagine, it's felt on a daily basis. I mean, in the Supreme Court world, some sittings for the Supreme Court, there are more men named Paul arguing than women. And there are some full years on the Supreme Court where not a single woman of color argues a case. So you would think that, given that women have been 50% of students in law school for the last, I think, 30 years or so, we would have more women in leadership positions at law firms, women arguing before appellate courts. And that's just not happened. And I see my friends, not reflective of how diverse our law school class was now, more than a decade out from graduating law school. So it's one of those things, at least for me, when I was in law school, it wasn't something I thought about a lot, because I just figured, oh, this is all a pipeline problem. Our, law school class is 50% women. This should all be fine. And I can say from my own experience, it's not a pipeline problem. And it's important for us to continue having these conversations. Even if the ERA is completely recognized, we still need to work to change some of these systems.
also think it's important to recognize that so many of the examples folks are using are actually would not literally be impacted by the ERA, because it applies exclusively to state actors, to governments. And so private law firms, schools, private schools, all sorts of employers, those entities would not be technically covered by the ERA. But what final ratification and acceptance of the final ratification of the ERA would mean is a kind of culture change throughout society, and not just the technical entities that would be regulated specifically by the ERA. You know, when I was a kid, my my music teacher told me I couldn't play the saxophone. Probably a gift to our family, but that I couldn't play the saxophone because I was a girl. And we played basketball in my middle school, and the girls could only run half the court. We had one set of girls that ran in the back court and the other set of girls that ran in the front court, because our uteruses would fall out. And when I applied for a job to work for a senator in the summer of my junior year in college, I was told that they wouldn't hire me because I was just going to get married anyway and have children, and it wasn't worth training me. Now, I was a lesbian, I still am. I had no plans to have children. It was less common for lesbians to have kids in the late 70s or early 80s. So actually hiring me would have been a great thing, because I actually wasn't going to have kids or get married, because marriage was not legal yet for same-sex couples. But people just said that stuff right out loud to your face. And so I have certainly in my own life experienced, and those are just a few examples, lots and lots of explicit sex-based discrimination, never mind homophobia and other gender identity-based discrimination, that is still part of our culture. And the ERA wouldn't reach really any of that technically, but what it would do is signal a change in the society, that stuff just is not okay, and we live in a different society now than we did then. And it's on all of us to make that culture change, which is part of what I love about Generation Ratify, is the way in which all of y'all have owned this issue and said, this is about our lives and our future and the world we are building, not the one that I grew up in, but the world that you're in. And the fact that it is something that has energized young people, to me, is just so exciting. And the ERA of today is a little bit of a different ERA than it was in the 1970s. And that's great, because society has changed, movements have changed, we've broadened, we've gotten deeper and more sophisticated. So I just want to thank you again for including us in this conversation, and to urge people to go to this convention in Seneca Falls in July, because it's going to be so fantastic.
Thank you so much for making all those amazing points. And I agree. I think that the Equal Rights Amendment can be applied to so many issues. And while, as Katherine said, that it technically only discusses discrimination on the basis of sex, it can be applied to numerous issues that affect all people of all ages and all groups. Abortion, trans rights, numerous lists of things that we can help progress with the Equal Rights Amendment. And I just want to touch back on a question in the chat. So this is they actually touched on the question that I was going to ask, so I'm just going to paste that question. And you already kind of discussed this, but I think the audience wants some clarification regarding the difference between the 14th Amendment and the Equal Rights Amendment. And what is it that the Equal Rights Amendment will address that the 14th Amendment did not address? If you can really touch on that again for the audience, that'll be great. And I can pass it to, I'll pass it to Michelle.
Yeah, so the Equal Rights Amendment says equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. And someone can jump in if I got any of that wrong. So that's essentially what the Equal Rights Amendment says, and it's pretty explicit and clear. The 14th Amendment is a little bit more complicated, and I want to kind of make sure that I pull up the exact language of the 14th Amendment there, because it's a lot longer, So the 14th Amendment, at least Section 1, says all persons born and naturalized in the United States and subject to its jurisdiction are citizens. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. So it's much broader and more vague. But if you look at the historical context of the 14th Amendment, and you're kind of looking at it from an originalist lens, there was an effort to have the Reconstruction Amendments expressly grant women the right to vote, for example. And the reason why the suffragists in the United States weren't as supportive of the Reconstruction Amendments was because that this was not used as an opportunity to protect women. And so if you're going to look at interpreting who was covered by the 14th Amendment with an originalist eye, that kind of vague language in the 14th Amendment from an originalist interpretation likely would not be understood to protect women. So I think that's it's much more express in the Equal Rights Amendment. And if you are then interpreting the Equal Rights Amendment from an originalist lens, you won't look at what people thought in the 1800s. You will look at what people thought. I think today someone might say the 1970s, but either way, much more recently.
I hope that cleared up for our audience. And go ahead, Catherine.
Let me just add one thing is that what the current the equal protection of the laws that Michelle read, I mean, what does that mean? I mean, what does the equal protection of the laws mean? It's something the Supreme Court has had to interpret, and they've done it in a pretty narrow way. And they've done it in a way that amounts to what we call formal equality, that M's and F's have to be treated the same. And that certainly you can't have animus towards M's or F's in any of your policy making. But the court hasn't interpreted it in a way that laws have to make sure that they don't perpetuate forms of inequality, whether it's race or sex-based inequality. And so there's a difference in the way we think about equality between formal and substantive equality. In the paper that a report we recently issued at the ERA project called the Sex Equality Gap, which you can get from the link that's in the chat. We explain the difference between formal equality and substantive equality. And we also point out that all of the sex equality protections that we've seen enacted in the United States from the 1960s until quite recently have largely, if they've benefited anyone, it's been white women. Women of color have overwhelmingly been left behind. And so we have to be thinking about who are the people who are the most disadvantaged by both sex and race-based equality or discrimination, and putting women of color at the center of our paradigm has to be the way we think in a modern way about equality. And that report just walks through all these different sectors where it's quite clear that if anybody has benefited from the equal protection clause or the laws that Congress have passed, it is white women, the most privileged women in society, and that's not good enough.
Thank you. And since we are nearing the 7 p.m., we are going to extend it for audience Q&A, but I do want to make sure that our audience gets the full depth of that historical perspective. So this next question I'm going to direct to our panelists is regarding the history of the Equal Rights Amendment. So if you can discuss the trajectory from the founding of the United States to suffrage in 1920 to the ERA proposed in 1923, what is the significance of that suffrage struggle, and what key issues were left unresolved that led to the proposal of the Equal Rights Amendment? I'm going to direct this question to Rhea.
This is a dissertation prompt if I ever saw one, so I'm going to pick up a few threads of this question, and I'm happy for Katherine and Michelle to help me out. I think one of my favorite moments around suffrage, since we've already talked about Crystal Eastman today, was after the 19th Amendment was ratified. She gave a wonderful speech titled "Now We Can Begin." And I love this speech for so many reasons, including the fact that it could be given almost verbatim today and be just as relevant as it was in December of 1920. But also because she saw the passage of the 19th Amendment not as the end goal of the suffragist movement, but rather as the beginning, right, as a springboard. Now that we had the right to vote, what could we do with it? And the issues that she immediately had focused on were things like the gender wage gap, access to contraception, unpaid housework, right? Weaponized incompetence by men, right? Many of the same issues that we're still facing today. It's just either remarkable how prescient she was, depressing how little progress has been made in the last 100 years, or possibly both at the same time. And so that moment, right, then set off, and Crystal Eastman, as I said, was one of the drafters of the ERA, right? So that moment set off, what would that real project look like now that we have the right to vote? Since we've talked a little bit about race, I also feel compelled to say that, of course, suffrage for women really in practical terms meant suffrage for white women, and the passage of the Voting Rights Act in 1975 was an effort to redress the very real barriers that were imposed for people of color, particularly Black people, both men and women, to vote. So suffrage was even then only partial suffrage, but it did create opportunities to imagine a new America. And I think Crystal Eastman's speech sets it out really well.
Just want to open it up to any of our other panelists.
Well, our ideas of what it means to have a sex, what sexual difference is or should be understood to be, were very different in the 19th century than they are now. And I think there was very much an alive sense of separate spheres that we saw in this society, that women were different than men, and that difference was something that should be celebrated, not the basis of our subordination. And there's large strands in feminist theory of this as well, cultural feminists or different feminists who said, actually, we don't want to make women the same as men, according to some kind of liberal neutral standard. Women can get pregnant. Women live in the world differently. We're more emotional. We're more connected than men are. And the problem of sex discrimination is that those things which are typically associated with femininity are treated less well than things that are typically associated with masculinity. That was a very strong thread of the feminist movement up to and even through the 1970s and 80s. And I think much of that view has been, we've kind of put that behind us, and it's seen as somewhat old-fashioned. And that's why the connection between sex-based equality and gender identity and sexual orientation-based inequality is so much a central part of the feminist movement today, that these movements have come together and see each other as having stakes in each other's movements, if not that we are all the same movements. And that these ideas of sex identities being so different, men from women, but that actually these are much more plastic, if you will, categories. And that one of the forms of patriarchy that we live with is that women are different kinds of creatures than men are, is something that we need to question as part of our feminist thinking and politics. And so that's true of any movement for social justice. I think we could tell a similar story about racial justice, how it has evolved over time, and that the kinds of ways we understand our identities are different today than they were, say, in the 19th century or the early 20th century. So I think what sex means and what sex equality means are quite different now than they were at the time of the Equal Protection or 14th Amendment, Equal Protection Clause or 14th Amendment being ratified, or even in the 1970s when the ERA was first introduced.
I think, yeah, building off that, I think a lot of times when there's an effort at obtaining equality for a particular group, people who oppose that effort will endeavor to create divisions and to create fractions within those groups. So when there's an effort to obtain the right to vote for based off sex, then you can there's tension. There was tension historically, right, created between Black women and white women. And in fact, one of the big criticisms, and folks can correct me if I'm wrong, if this wasn't Alice Paul, but if it was Alice Paul who made the decision, right, that during a big march that the Black women were asked to be in the back of the march because of this effort, like, well, we'll make more progress if we don't make it, about, okay, so Kate said it was Alice Paul. But when there is an effort to kind of obtain more equality, a lot of times the other side or even internally, there can be these divisions over who should be at the center of this issue. And during, the civil rights era, we didn't see as many women of color, being the leaders in that space, not because they weren't capable of it, right? But because of kind of internal tensions there where women were not like given the platform to really be as strong advocates in this space. And I think in the ERA context, there was an effort to create tension about who's included in the ERA. What does sex even mean? Does this mean that this is going to protect people who are transgender? And efforts to kind of create divisions within those groups too. And I think it's really important to resist that effort and view the ERA from a more inclusive standpoint. And I think even in the last 5 years, as the ERA movement has evolved and has evolved towards younger people like Generation Ratify, there's less of a success of an effort to create internal tensions in terms of who should be included and who should be protected. And the ERA is understood and welcomed as something that's more and more inclusive.
Thank you again. So with our last few minutes here with the official round of Q&A, I do want to open it up to the chat, but some questions that have been coming up that I'll just start us off with are, how will the ERA not meet the same fate, kind of as we discussed with the 14th Amendment and other legal protections that have been passed so far? How will it not meet the same fate of benefiting white men more at the end of the day? And how are we going to make that discrimination clause more broad and more applicable to all the amazing other topics that we discussed today that the Equal Rights Amendment should eventually be applied to? I'm going to pass this on to Ria because I do know that she has to leave at 7.
I do, and I'm sorry I won't be able to stay on for the extended Q&A, but I have no doubt that you will be in excellent hands with Katherine and Michelle. We talked about this some earlier in the panel. I think it really will be up to us as advocates to show judges interpreting the ERA that there is another way, right? Once upon a time, back in the Katherine, the professor, can give me the year for caroling products, but right, the first time that the Supreme Court suggested that perhaps the Equal Protection Clause meant a more searching form of judicial review for some kinds of classifications, right? They were writing on a blank slate, but they knew they were writing on a blank slate, right? And from there, the law developed over the past, I'm going to say 90 years. That's my ballpark guess. We can check the data on this later. So the same will be true for us, right? What does it mean to write on a blank slate? And I think for all of us who came of age as litigators in a time when there's been very well developed discrimination case law, constitutional and statutory, it can be hard to imagine what that looks like. And it reminds me of a time when I was a newer lawyer and I was at the NAACP Legal Defense Fund, and we used to have a library of every brief that the LDF had filed in the United States Supreme Court, and you could go sort of touch the briefs, and it was kind of amazing, and you could like sit at Thurgood Marshall's desk and just bask in it. And I remember going to read the brief that LDF filed in a case called the Griggs v. Duke Power Company, which was the first Title VII case to recognize disparate impact discrimination, what we talked about. So a facially race-neutral policy that nonetheless has an unjustified adverse effect on Black people that can't be justified by any legitimate reason. And so reading that brief, right, this was the first disparate impact case. There were no disparate impact cases to cite, right? It was writing on a blank slate in a way. And it was a remarkable thing to me to read as a lawyer because it was so different from the kind of briefs that we write now. It was, it was essentially a story about what Title VII Civil Rights Act could mean and did mean and ought to mean. And I think it will be on us as advocates to write that same story for the ERA, right? To not be constrained by what's come before, but to really think broader, to imagine if we're starting from first principles, and then to invite judges to join us in that world, right? Where we're not constrained by prior constitutional amendments, because this is a whole ass new constitutional amendment and we can start over.
Whole ass is a legal term that you should write down. It's a very important legal term. That's great, Ria.
I think that's a fitting note for me to sign off. I'm going to leave you with Katherine, Michelle, and Pooja. Thank you all so much.
Everyone, please say thank you
Take care,
to
Ria.
Ria in the
Thank
chat.
you.
Thank you so much for being here with us today.
Yeah. So the thing is, what we could have done is amend the 14th Amendment. You can amend an amendment. And if we wanted to just add women specifically to the Equal Protection Clause and or make sure that sex-based equality got the same treatment as race-based equality under the 14th Amendment, what we should have done is amended the 14th Amendment. But by creating a whole new amendment, the 28th Amendment with different language, Michelle gave it to us earlier, in the 28th Amendment, there's no reason why it should have any relationship to the 14th Amendment at all. It's a new source of equality rights. And it's our job to be talking about it publicly in the media with our friends, with our elected officials about what it should do, because it will do what it does because it's pressured to do that, right? Judges will have to interpret the 28th Amendment in ways that are different than the 14th Amendment because we create a culture of understanding the 28th Amendment as something different and better. So that's there's work we need to do in Congress to get them to finally lift the deadline and all of the kind of impediments, legal, whether they're real or not, they're there, impediments to the final ratification. But the bigger work is the culture work about what kind of vision of equality and citizenship the 28th Amendment would mean. And that's why I'll just come back to Generation Ratify, that the kind of visioning work that you all are doing is just so important.
Yeah, and I think also recognizing that judges don't live in a vacuum. I mean, unfortunately, many of them live in their own silos and echo chambers where they're hearing certain messages in certain ways, which is all the more reason to make sure that we're not living in our own echo chambers and that we make an effort to have open conversations with people who might come at the world from a different perspective. But the reality is that the 28th Amendment in the federal Constitution is going to be interpreted by federal judges, meaning the judges who are on the bench right now, like them or not, are going to be the ones who are making these decisions. And ultimately, it's going to come down to the US Supreme Court. And so cases need to be framed in a way that can persuade the justices that are currently sitting on the US Supreme Court, because they're the ones who are going to make the decision. And you might draw a great district court judge, but then it goes up to the Court of Appeals. And if the Supreme Court doesn't like what the Court of Appeals did, it's going to go to them. So I think also knowing your audience and I don't think that means it's a lost cause. I think it means that it's so important to have these open conversations in a way that can help other people who might come at the world from a different perspective really understand where you're coming from and really understand why there is a need for a broad ERA. And that effort is done years before a case is actually heard and decided by the Supreme Court. Now's the time to set that groundwork, and now's the time to have conversations with people who disagree about what the ERA says or might want to interpret it a different way. So, you're making a difference with every conversation you have and every effort you have to really kind of get out there and expand people's perspectives.
So I just want to open it up again to the audience. If you have, Julia has a question. Feel free to unmute yourself.
Hi, everybody. So I'm overwhelmed by this brilliance. Okay. My name is Julia. I live in Jersey. My question, so I just learned recently from Lauren actually about the Bostock versus Clayton case where sex extends to protect gender identity and expression as well. And so I was wondering, gender as a construct is so often grouped with sex to promote discrimination. And I was wondering specifically, like on a technical level, with the ERA. So how has, I guess I'm looking for vocabulary, cases, facts to further address how gender as a construct, sorry, hang on, let me think about this for a moment. So many words floating around my head. I guess I'm looking for more facts and cases as to how sex can extend to include gender expression and the entire spectrum of humans to make an accepting constitution.
Well, we have the Supreme Court to thank to have answered that question already. And Justice Gorsuch, is a very conservative member of the court, and other conservative members of the court having ruled in the Bostock case that sex equality protections in federal law, federal employment laws, necessarily include sexual orientation and gender identity discrimination. So when an employer discriminates against an employee on the basis of their sexual orientation or their gender identity, they're engaging in sex discrimination. And so to have a conservative Supreme Court have already answered that question definitively is very helpful. We also have the opponents of the ERA, starting with Phyllis Schlafly up to, you know, Ted Cruz and Josh Hawley and all those horrible people who are in the Senate now opposing legislation or resolutions that are in the Senate that would lift the deadline. And we heard this at the hearing that was in the Senate quite recently, because they're afraid the ERA would create constitutional equality protections on the basis of sexual orientation and gender identity. And so it's really great when our opponents say that stuff, because once we get the ERA finalized, we've got it on record that it includes sexual orientation and gender identity. That's why they didn't want it, but they lost. We won, right? And so I think that question has actually already been put to bed by the Supreme Court and by the opponents of the ERA, who are trying to keep it from being finalized because they oppose sexual orientation and gender identity protections, which they see are necessarily part of the ERA.
Although the litigator in me has to put a bit of cold water on that. I find legislative history is convenient when people want to use it, and then they say, oh, it's completely irrelevant when they don't want it. So it can be very persuasive, but again, courts are going to do with it what they want. And so I think that the key to convincing courts, at least then, is to get them to want to rule for you, because then they can accept legislative history when it's convenient, disregard it when it's not convenient. But the heart of it is to get them to want to be able to recognize your argument. And look at the face of the ERA itself. Like, who can actually read that language and say, no, I disagree with that, I oppose it? A lot of the opponents, like there were pins in Virginia saying that ERA stands for everything related to abortion. Well, the word abortion doesn't appear in the ERA. I mean, a lot of people will argue that the ERA should encompass reproductive rights, but people have to go beyond the face of the actual very simple text of the ERA to invent arguments to oppose it. And so often, if your argument is the simpler of the arguments and you're on kind of the right side of things, you're starting from a really good place.
You know, with this last issue of the relationship between sex equality and the ERA and abortion, there's a case before the Pennsylvania Supreme Court. Keep an eye out for it, because we should be getting a decision pretty soon. And it's a case in where reproductive justice and women's rights advocates in Pennsylvania sued the state, challenging a law that prohibited public funding for abortion. And they used the state's ERA. Remember, there are 26 states across the country that have added ERAs to their state constitutions. So explicit sex equality protections are in the state constitutions, and they're an underutilized source of sex equality rights by and large. So in Philadelphia, they said, no, let's use our state's ERA to challenge the ban on Medicaid funding for abortion. And many people worked on that case, and we submitted a brief to the court outlining all the different ways in which denying access to public funding for abortion amounts to sex discrimination. Here's a path, here's a path, here's a path. You pick one of them, but you end up at the right spot no matter which path you pick. So keep an eye out for that case, because if the Pennsylvania Supreme Court says that the ERA includes abortion rights, or at least prohibits limitations on access to the full range of reproductive health care, because that's a form of sex discrimination, that's pretty powerful in terms of culture change.
And I think New Mexico already has a ruling essentially to that effect too.
They do.
So one thing that I think people, you know, who've come at the world from a progressive standpoint have really focused on is federal courts and vindicating rights through federal lawsuits and federal courts. We think of Brown v. Board, all the way through Lawrence v. Texas. Like, we see the Supreme Court as the place where we go to vindicate our rights. We've ignored states largely. And as somebody who came from a state, I mean, states are places where not only can you actually substantively vindicate rights based on rights given by state constitutions, you can also help frame the mindset about how to interpret federal law. Because if all the states interpret very similar language a similar way, it's hard to counteract that to say, no, a federal statute that has similar language or a federal constitutional amendment should be interpreted differently. And so I think engaging on a state level and helping mold the law to evolve on a state level is something important. One thing I haven't seen people do as much of that they really can do is look to see if you can get a state attorney general opinion. I mean, it's a big deal to file a lawsuit. People can definitely do that and get state courts to weigh in on an issue, but state attorneys general issue pretty persuasive opinions. They kind of serve in somewhat of a judicial function. And I think it's an underutilized tool for all kinds of people looking for clarity on the law. So one thing each of you can do is go look to see if your state attorney general is able to issue opinions, and then see who can request an opinion from an attorney general. Often it'll be someone in a position of government. So maybe you can ask your state senator or state representative to ask the attorney general to interpret your state's equal rights amendment or some other provision in state law that can help build an interpretation of the law in a way that protects the rights that you're looking to vindicate.
I think this is such an incredibly important point, and state actors who are going to be governed by the federal ERA as well have a role to play in the finalization of the federal ERA. And so if you live in a state where your state ratified the ERA, was one of the states that voted to ratify it, you should be talking to your attorney general, your governor, other executives, public executives in your state, to be part of what we're calling an as-if strategy, as if the ERA actually is the 28th Amendment, right? It is the only amendment that has satisfied all of the constitutional requirements to be added to the Constitution and has not been recognized by everyone as part of the Constitution. Talk about sex discrimination, right? So your governor in your state could say, hey, we voted to ratify the ERA. We're going to consider it binding on us, that it's in effect now. We're going to do things to comply with the ERA because we now see it as finally ratified. So that lots of different actors can play a role in declaring the ERA valid, not just President Biden, not just the archivist. There's so much focus on the archivist, like he doesn't even have a constitutional role, but governors do. So there are lots of interesting and creative strategies we could be pursuing that I'm looking forward to partnering with the Generation Ratify folks and others of you on this webinar to kind of roll this out. And one of the things that we'll be announcing in the fall is a final, or at least the next step in a policy agenda for state executives on how to implement the ERA in their states, whether it's their state ERA or this as-if idea of we're going to act as if the 28th Amendment were law and it's binding on us. And we're going to hopefully have some of you help us put pressure on local executives, state and local executives to implement this policy agenda. I love that as if sounds like Legally Blonde.
I was just about to comment on that. But I think we are nearing the end of our time. I just want to thank everyone for being here. Thank you for supporting this cause. Thank you if this is your first time being here. And if it is, please, please, please sign up for the remaining workshops we have this month. And I just want to give a virtual hand of applause to our panelists for taking the time to be here today, answer our questions, and give us such an in-depth historical and legal review of the Equal Rights Amendment. So I give a little round of applause. And
for you too, Pooja. Thank you.
No, thank you. And I just want to ask if the panelists would like to share any last thoughts. You already answered all the questions in the chat that I was going to bring up, so.
Just, I would love to work with you all on this. So please don't hesitate to reach out. My email is pretty easy to find online, but really, if there's anything I can do to support you all in this effort, I would love to do that. If you have an interest in learning more about like law firms and what they can do, or state government, or federal government, I didn't mention, but I have some federal government experience too. So please, like, you can view me as a resource to you both in the ERA effort and also for you all kind of professionally. I really think that this ERA community is a fantastic community. Generation Ratify is doing incredible things, and I would really love to help in any way I can.
Definitely. So everyone here is on the chat. Feel free to reach out, and the ERA project will be sending out all these resources, all the recordings of all these workshops later, and a bunch of resources for you all to become legal experts and be on a panel such as this one, like in the future. So with that, I will end this panel and another round of thank you to our panelists and our audience.